the original.
Samson, thank you so much for the opportunity. Kindly allow me. You see, let me start because of what has been said. As for the submissions of Council Bento, Dr. Bonfe, I think we've gone past that stage. And so I would not spend much time on what we have is what is before us. A bill has been passed by Parliament, and a lot of things are being said. I will not shy away from the fact that we have a problem, and it is beyond what we have in our criminal code. And so we need to do something about it. I support this. Samson, let me say, from where we have come, that this thing he said, Honorable Intim Fourdjour said that, and it's often been said, that the bill as passed in 2024 never was sent to President Akufo-Addo. It's not true. If you read the letter signed by Nana Asante Bediatiu, the first paragraph, if you read it, I'm sure you have it. He said that they were in Peduase and they learned that the clerk was in the Jubilee House to present the bill. This is what what's his name?
Asante
Bediatiu. This is the letter he wrote to the clerk.
Let me attempt to read that letter. It's dated the 18th of March, 2024. Transmission of the Human Sexual Rights and Family Values Bill 2024. It has come to the attention of this office that while the President and other senior officials of the presidency were at Peduase for a cabinet retreat on Thursday, 14th March 2024, you attempted to submit the Human Sexual Rights and Family Values Bill 2024 to the Jubilee House for the President to signify his assent or otherwise to the bill. The office is aware of 2 pending applications for an order of interlocutory injunction, both filed on 7th March in the Supreme Court, one by Dr. Amanda, and then the one by Richard Sky, and so on and so forth. This where it narrated everything and then says that in the circumstances you are kindly requested to cease and desist from transmitting the bill to the President until the matters before the Supreme Court have been resolved.
Samson, yes, so it is not true, first and foremost, that it was never sent. It was sent and was not received. So there is a difference. And that is the height of unconstitutionalism in this country. The President had no authority under any law to have done what he did. Because the work of Parliament ordinarily should end where the bill is presented to the President. The law states what you should do beyond receipt of the bill. If you decide not to assent to it, you have a problem with some provisions, you state it in a memorandum to the Speaker. If you decide to do it, to assent to it, you proceed under Article 106. So the President did not have that legal mandate to refuse the bill, and that must be said. And then in any case.
So that was only intended to avoid receiving it, then being compelled to sign. The question that is being flipped today is that the manner in which you are going about passing it is to avoid making sure that it gets passed.
Not at all. I'm coming to it. But even on that, in any case, the Supreme Court dismissed the action of Richard Sky and then
Amanda.
I think on the 18th day of December 2024, few weeks before President Akufo-Addo left office, he could have recalled it in a similar letter to the clerk and then assented to. So it's clear that he just didn't want to sign or assent to the bill. That is a fact. Now, beyond that, this matter, of course, the discussions could be situated in 2 different folds, procedural and substantive, and you agree with me. With the procedure, I don't begrudge the Speaker for the way he spoke, because he wasn't in the chamber. The presidency, regardless of his knowledge about parliamentary, whatever, he wasn't there. He heard people talking, so surely he should be concerned. I was there throughout. What happened? After the President Akufo-Addo refused to do what he was supposed to do, we came to the 9th Parliament. And it was the Speaker eventually ruled, because of time, that the bill had to be reintroduced. We didn't have to, because the old parliament, the 8th parliament died with that. We've gone through that. If anybody disagreed with the speaker, the law allows the person to have filed whatever. So the decision of the speaker was that we should go through this again. The sponsors of the bill, and let me state here, it is not true. I wish Rev.Intim Fourdjour, you see, I asked him if he had a copy. All what he said, he could not prove to you a copy of the 2021 bill. He didn't have it. What he held was the 2025. It is not true that the bill as they had in 2021 is the same thing they presented in 2024. It's not true, and I'll prove to you. It's not true. They, the sponsors, did some work in the bill before they submitted, and I'll prove to you. He's saying that who changed it? Indeed, even with the clauses and the sections, he said who changed it. You present your work to Parliament before it is referred to the Constitutional and Legal Committee. What did you present? It is not the same. It's different. I'll come to it. But with the procedure, Samson, the speaker said that he left a message that we should only consider. And if you heard the speaker correctly, he only said that he was surprised because MPs usually on Fridays we leave for the house earlier because we intend going to our conference. That's true. So some of us, yes, we thought that we were doing in fact, the then speaker said that we should do the consideration. But when we finished,
what naturally follows?
What naturally follows? What should we do? The only thing you can say is that we overworked. Because that day we stayed beyond the time we usually stay on Fridays. What is unlawful about that? We do it. Budgets, passage and all that. Some we sleep in the chamber. What's wrong with that? Is it unlawful? No. See, they refer to our standing orders, Order 17 at the third reading, 172. And you see, the challenge I have, Samson, is the sheer hypocrisy. If you refer to read in full, what does it say? It says that, yes, where and with your kind permission, the consideration stage, and then the 172. Where a bill has passed through the consideration stage, the third reading shall not be taken until at least one sitting has elapsed. That's true. So what has been said is that we needed a sitting before the passage. That has been said. But there is an exception. Now, what does the section say? It refers to, it said a motion for the third reading of a bill shall not be made on the same day as the second reading, except as provided for in Order 160. So what does 160 say? You have to go to 160. And 160 is clear here. It refers to urgent bills. And it's procedural. So if we want to go contrary to 171 or 172, you need to demonstrate that it is under 160, which is urgency.
So this bill came under urgency.
Urgency. In fact, you are supposed to move a motion.
Was that moved?
It was moved. I have it here. It was moved by Honorable Dafiamapo and was seconded by the majority leader. It's here.
My man Rocky.
Yes, so that notwithstanding, these are copies of the vote and proceedings for the day. That notwithstanding the provision of Order 1721 of the standing orders, which requires that when a bill has passed through the consideration stage, the third reading thereof shall not be taken until at least one certain day has elapsed. The motion for third reading for the Human Sexual Rights and Family Values Bill 2025 may be moved today. Moved by Honorable Majority Chief Whip and Member of Sabdai, Mr. Roxanne Nelson Eche Dafiamapo, on behalf of the following, included Honorable Intim Fourdjour.
Yeah, he got up and washed his hands off.
No, that was subsequent. I will deal with the substance. He had a problem. If you've watched it, until recently, they never had issues with the procedure. Because he was in the chamber. I'll come to the quorum aspect. He was in the chamber.
Let's go to the quorum quickly.
So the quorum, yes. With the quorum, I hold in my hands here the vote and proceedings for the day. Of course, we all know the Justice Abdullahi case. Vis-a-vis 102, 104 of the Constitution. We know it's not in doubt that you need 1/3 to start business. If you want to take a decision, you need more than half by the Justice Abdullahi case. Mm-hmm. But operationalization, if you want to operationalize 102 and 104, you come to our standing orders. The Constitution doesn't give you how to operationalize 121.
Help us understand.
Yes. That. So when you look at when you look at, I think it's 64, standing order 64, it talks about quorum. And it says, 1, a quorum, and it refers to 102. A quorum of parliament, apart from the person presiding, is 1/3 of all members of parliament. 2, where the person presiding is a speaker of parliament, he shall be counted because of the Justice Abdullahi case. This was now put in. He shall be counted. 3, a member, and this is where the operationalization, a member may draw the attention of the person presiding at any time during a sitting that members present in the House constitute less than 1/3. So you need to raise it. Now, 4, the person presiding, and this is what the person presiding ought to do if it is raised. A, direct the clerks at table to cause the bell to be rung. So it's not as if all of a sudden after it's been raised, we adjourn. No, it directs for the bell to be rung. B, continue the business of the House for a period of 10 minutes. So we don't even suspend immediately. We continue for 10 minutes. C, direct the clerks at table to conduct a head count of members present. And then D, if there is still no quorum, suspend the sitting for a period of no more than 1 hour. And 5, if upon the resumption of the sitting after the 1 hour, there is still no quorum upon the conduct of the head count, the House shall stand adjourned till the next sitting without quorum being put. So, Rev.Intim Fourdjour and the respected minority leader were all in the chamber. Nobody raised it.
Indeed, nobody raised the issue of quorum.
Nobody raised it. But per standing orders, you needed to have raised it.
Okay.
So that we go through this. Indeed, in determining who was in the chamber, I do not know what anyone else is relying on, whether it was what you saw on the television. I hold in my hands the vote and proceedings for that day, the Friday, 29th day of May 2026. And what we do in the chamber is that when you come, you register your name in a register. The number of persons that registered their names as present were 193. Samson. 193. In fact, if you decide to litigate on quorum, this is the only document you have to rely on.
But that's for ordinary business.
Thank you. But the thing is that maybe a lacuna, which you may have.
That's for ordinary business where you need 92.
I want to.
Now you have more than 92 for that ordinary business. But to take a decision, you need 138 or so.
Samson, I'm coming to it. This is the only time we register in Parliament for anything, whether for business or except where somebody challenges the voice vote.
Okay.
Then we put it to count. If you remember the case of the Justice Abdullahi, it was a vote. What do you call that one? A vote where they were counting people, and the deputy speaker rose and came to vote. If you remember, so there was evidence that the number of people for business for passing any decision there was verifiable. But in this case, it was a voice vote. So there is nothing in Parliament beyond this.
Because the objection was not raised. It's too late.
It's too late.
Okay, so
we come past that. Let me come to
this. Sounds like ordinary company law, but you said this has been passed under certificate of urgency.
No, I never said certificate of urgency. I'm saying that
because that's the only
yes.
That's the only exception.
No, you see what happened. If you look at the standing order that I read, the one. If you 172 refers to 160.
Yes.
So when you look at
160, the 160 talks about urgency.
Yes.
Is that different from certificate of urgency?
Urgent bills. Yes. So this is a private member's bill.
Yes.
You understand?
So it cannot be passed under certificate of urgency.
But you see, it is referring to it saying, if you look at 172, Samson, he said, where you cannot do this unless it is provided for under 160. And the 160 says that a sponsor may submit a bill without publication in the Gazette. The Speaker shall refer a bill to the appropriate committee of this, where the committee determines the bill is of an urgent nature. Because we had gone through this before and it wasn't passed. You remember how many weeks did we take to undergo this? So surely, even though I don't have the evidence here, this was because it was admitted by the Speaker and it was ruled upon. If you look at the votes and proceedings, so I am of the view that it was considered under standing order 1.
Certificate of urgency.
Well, you may put it that way.
But a private member's bill cannot be passed under a certificate of urgency. So now you understand that this passage is riddled with all sorts of unconstitutionalities.
It's not. No. Well, how is it unconstitutional?
The point I'm just bringing to your attention now. All right, so
I'm saying that it's the substance. It's something I want to. It's very important.
Do that quickly. We need to go to the facts.
Because when you look at
more important issue about that.
Thank you. But you see, with the substance, this Honorable Intim Fourdjour was struggling, of course, because when you look at, I have said that the bills were not the same. It's not true unless anybody shows me contrary evidence that with the 9, with regards to the old bill, they started with subject to the Constitution. Let me see that anybody who has a contrary opinion. It's not true.
But that's what Sam George told me last week on the show.
No, but the majority leader on the floor said that they didn't have it. And what I have here...
Who should we be
No, I've told you what...
Sam George is also a sponsor. He said he was subject to. And so what has been done is actually not different.
No, subject to is what they did.
Now we are told that Mahama Ayarga says there was no subject to.
No, Samson, hold it. I am saying that what they submitted this time around had it. But the 2021, it didn't have it.
Okay.
That's the point I'm making.
So that was problematic.
That was problematic. No, they even brought what they brought this time around, had the subject to.
No, I'm saying that the older version,
it's problematic.
If they didn't have subject to the Constitution,
you may give
then
your
that
verdict.
Was problematic.
You may give your verdict on that. But I'm saying that this is what I have for the older one. And that one is section 12. This is what a person who through media, technological platform, technological account, and any other means produces whatever. When you look at the 9 here, Samson, it's very important. Please allow me. When you look at the 9 here, it tells you that, yes, when you look at the 9, it says subject to the Constitution. And the subject to the Constitution, Samson, who is saying there is any problem with it? Who is saying so? Sorry.
Subject to the Constitution, I can read that for you.
Please. There's been so much.
It says, it says, subject to the Constitution, a person shall not produce, procure, market, broadcast, disseminate, publish, distribute, whatever.
Yes.
So what's the point?
Yes. So they brought it now. Then the committee met, and then they did some amendments. And the amendment, we are now being told that it's problematic.
We have gone through that.
You've gone through.
Yeah, I need us to move on. That's what.
Yes. So there is nothing wrong with it. Samson, even with regards look at section 11. This issue about people are being exempted with regards promotion.
What does section 11
say? Section 11 states this. Let me do that quickly for you. Prohibition of funding. And nobody is mentioning section 11. Prohibition of funding, sponsorship or promotion of prohibited acts. Section 11(1). A person shall not fund, sponsor or promote an act prohibited under this act. Nothing has been done about it. So if you're a lawyer and you want to come under the 9 with the 9(2), yours is to do your legal thing. If you go beyond that, and perhaps you grant an interview on behalf of your client, and you state that there's nothing wrong with LGBTQ people, then you come under 11. Because with 11, whether you're a pastor or a carpenter, you fall under nothing.
Read 11 again.
Let me read it. Prohibition of funding, sponsorship, or promotion of prohibited acts. 1. A person shall not fund, sponsor, or promote an act prohibited under this act. And 2, a person who contravenes subsection 1 commits an offense and is liable on summary conviction to a term of imprisonment of not less than 3 years and not more than 5 years. Okay. Just as what it says.
All right.
But Samson, I beg you.
I'm sorry, we've got to move on. We are tired of this particular debate. Sorry. That's why Rev.Intim Fourdjour had